Authentication. Every item of physical evidence must be authenticated. The proponent must show that the evidence is what he claims it is. Proving authentication. It may be proved by means that serve to establish authenticity. It's a low burden, so an item may be compared with already authenticated item. Self-authenticating evidence is writings that contain identifying information do not need a separate authentication, such as a deed, notarized document, or newspaper. Authentication issues. Ancient documents automatically authenticated if they are 1, more than 20 years old, 2, does not present any irregularities on its face, and 3, found in a place of natural custody. Photos must have personal knowledge to authenticate. Does not testify to whether the fact is perceived. Voice, whether heard firsthand or through a recording, a voice may be identified by anyone who heard the voice at the time. Non-unique items. An item facially indistinguishable from others of its kind, such as a bag of white powder or a generic syringe. Proponents must establish the chain of custody, that the proffered evidence is the same item it is claimed to be. So a will can be admissible absent large breaks in the chain. Best evidence rule. If evidence is offered to prove the content of a writing, an original document must be used unless it is unavailable. A writing is any tangible collection of data. It can be videos, documents, photos, books, emails, text messages, or computer devices or x-rays. Applicability. This rule only applies if evidence is offered to prove its contents. So the witness's knowledge is obtained from a writing. The case turns on contents of a legal instrument. Evidence sufficient to prove a writing's contents. 1, originals. 2, duplicates. Must be a machine or carbon copy. Admissible unless there is a genuine question as to the authenticity of the original itself. 3, testimony regarding contents. It's admissible if original is lost or destroyed, unless done so in bad faith by proponents of testimony. Voluminous document exception. A voluminous series of documents may be summarized in court. Originals relied upon must be available for inspection. Completeness doctrine. If a party introduces part of a writing or record into evidence, an adverse party may introduce evidence that should fairly be considered with it. Judicial notice. A court may recognize a fact as true without formal presentation of evidence, either on its own or upon formal request of a party. Judicially noticeable facts. Facts that are 1, manifest facts, those capable of verification by a source that is not subject to reasonable dispute, or 2, notorious facts, those generally known within the jurisdiction. Judicial notice of laws. Court must take judicial notice of federal and state laws and regulations. All other laws, court has a discretion to take judicial notice. So municipal ordinances, foreign laws, etc. Effect of judicially noticed facts or laws. Civil. Jury must take judicially noticed facts as conclusive. criminal. Jury may take judicially noticed facts as conclusive, but it is not required to. Judicial testimony. A preceding judge cannot testify as to the witness at trial, so no party can tell the trial judge to testify. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted. It is generally inadmissible, subject to certain exceptions and exemptions. Statement is an oral or written assertion or nonverbal conduct intended as an assertion. Non-human assertions are not statements. A test result, radar gun readings, dog barking, and out-of-court statements are not hearsay if offered to prove anything other than the truth of the matter they assert. Exemptions versus exceptions. Federal rules create both exceptions and exemptions to the hearsay ban. Exemptions. Deemed non-hearsay and thus admitted. Exceptions. Deemed hearsay but still admitted. Note, beware of answer choices that turn on this distinction, such as hearsay but admissible, or not hearsay and admissible. Beyond this distinction, there are no practical differences between hearsay exceptions and exemptions. They should be treated as the same. Note, witnesses' prior out-of-court statement can be hearsay. Thus, an answer that a statement is not hearsay because it is a witness's own statement is incorrect. Admissible out-of-court statements. Out-of-court statements are not hearsay if offered to prove anything other than the truth of the matter they assert. Common non-hearsay out-of-the-court statements. 1. Statements of independent legal significance. Statements contain legally operative words, not hearsay, because offered to show that the statement was said, not whether it was true. Such as in a contract dispute, A testifies that B told him a deal was done. 2. Statements offered to show their effect on the listener or reader. So in a negligence claim, a statement warning plaintiff of the injury-causing condition is inadmissible to show notice to plaintiff. 3. Statements offered to show speaker's knowledge. So a defendant charged with conspiracy claims, he did not know about the crime. Statements indicating defendant was told specifics about the crime will be admissible, indicating he knew it was planned. And 4, statements offered to show the state of mind. So statements offered as circumstantial evidence of declarant's state of mind are not hearsay. For example, statements by defendant before running into traffic and causing an accident that he is invisible may be used to show insanity. Compare a state of mind hearsay exception, which allows hearsay statements that reflect directly, not circumstantially, on declarant's state of mind. Non-hearsay exceptions. Statement of property opponent. Out-of-court statement is statements by a party are admissible if offered against that party. So judicial statements are made in pleading or testimony. Adoptive statements, acquiescence in another statement. Silence can be a statement of admission if 1, party heard, understood, and was capable of responding, and 2, reasonable person in the party's position would have responded. Vicarious statement. Statement by someone other than the person against whom the statement is offered arises with one agency. Statements by an agent employee on matters within the scope of the agency employment is admissible against principal. Two, authorized speakers. So a statement by one authorized by a party to speak on her behalf is admissible against the party. Or three, a co-conspirator. So their statements are admissible against the defendant if made in the furtherance of the conspiracy. Declarant witnesses prior statement. A prior statement by a declarant who testifies and is subject to cross-examination is admissible where the statement is either A, inconsistent with declarant's testimony and given under oath, B, prior consistent statement where it's admissible to rebut charge of fabrication, improper motive or influence, or rehabilitative credibility, or C, prior statement of identification after perception, admissible to identify a person as someone declarant perceived earlier.